Hi there, good day, and welcome to the Disability Law Show. Once again, John Scholes beside me, James Fireman, senior partner, Samfiru Tumarkin LLP. Just happened to be the most positively reviewed disability law firm in the country, coast to coast to coast. Reach out if you have issues or just questions. Have a conversation with James. He'll hook you up with himself or a member of his team. Really simple, 1-855-821-5900. Email is help@disabilityrights.ca. Lots to churn through today on the show, James. We're going to get to this. 3 key facts to remember if denied LTD, long-term disability. 3 facts coming up later on the show. But we always start with a situation that you're working on, brother. What you got going on today?
Well, there's a claim that I had taken to mediation quite recently. We got a nice result on it. But there was an element in that case that arose when my client was cut off about social media. And so social media posts are something that a lot of my clients are worried about. They're worried about the insurance company taking the things that they post online out of context and trying to use them against them during the adjudication process. And it is something that can happen. And so I want to give this example so that those out there watching have a sense of exactly what goes on and can use that to their own advantage down the road. So this particular client made a post early on during the pandemic when her kids were doing virtual learning. And she posted on Facebook about how she was now all of a sudden a teacher and a chauffeur and a nutritionist and a program director and a chef and a gym teacher and all of these jobs that parents have had to do during the pandemic to a much greater extent than they've ever had to in the past. And it's a post that's probably been made by hundreds of thousands of different parents during the course of the pandemic. And no sane person is going to take that literally. No one is going to read that post and believe that all of a sudden the person who's saying that is all of a sudden now performing the job of an actual chef or a chauffeur in the real sense. But this is, in fact, what my client's insurance adjuster did. They saw the post and cut her off. Now, the denial letter that was sent to my client wasn't so explicit. The denial letter actually was pretty vague. It didn't give the actual reasons that the insurance company relied on in denying the claim, that it was based on these social media posts. When I got the insurance file, after my client hired me, we requested the insurance file, and I went through it and found out that indeed that's exactly what happened. That they found these social media posts and very shortly after terminated my client's benefits. And so you might think that insurance companies are legitimately taking that position, and anytime you post something on social media, they're going to cut you off. Now, I'm happy to say that that is not in fact the case, that it is not every single claims handler that is going to take things so foolishly out of context as happened here. And I know this because we got to mediation, and it wasn't something that was even argued by the insurance company. They didn't even bring it up. It wasn't at all an issue for them when we got there. Very clearly, the lawyer who was there for the insurance company, as well as the representative of the insurance company, did not put any stock in this. But nonetheless, if you are in the long-term disability process, it is still something that you can learn a lesson from, because ideally, you want to continue getting your benefits as long as possible. The longer you get benefits, the easier it is for you. You don't want to have to bring a legal claim. If they cut off your benefits, that is your best option, but it's still better for you to get the benefits for as long as you're disabled from work. So what can you do in terms of social media to limit the extent to which your insurance company is going to try and use that against you? Well, first and foremost, look at your privacy settings. Take a look at what is available to the public at large. Your social media accounts should only be accessible by people who you know and are comfortable seeing what you are posting on social media. If you don't know someone, don't give them access to your social media account. And I would recommend going through your social media profiles and removing anybody who you don't know, who isn't someone that you want to have access to that information. And going forward, certainly you shouldn't be giving it to anybody that you don't know. I would also suggest that you limit the ability of anybody else to post things about you by tagging your image or your profile, and making sure that you have to approve anything where you're going to be connected to a photo someone puts up or a status update where they use your name, that it won't show up anywhere unless you've approved that before. And then the other thing is use common sense. don't post things that are likely going to be taken out of context. Even if they are, at the end of the day, fairly benign, it's still better to err on the side of caution.
Yeah, it's interesting how that landscape has changed. We used to talk about this years ago, and it's, I think everyone realizes that social media, for the most part, is shiny, happy people. These are the best moments in people's lives. But we had a guest years ago on the radio show. By the way, you can find the radio show. Just go to disabilityrights.ca, media drop-down menu. Remember, we had that guest on a few years ago, and he said basically go dark when it comes to social media if you're on disability. And you kind of argued that might be a little bit of an overstep, but I think I understand what he was saying, which kind of complements what you're saying, James, is just tread with caution when you put things on social media like Facebook and Instagram and et cetera, right?
Yeah, listen, I mean, it's certainly better if you don't have a social media presence, because then there's just nothing there at all. And that used to be what I told my clients years ago when social media just started. I would tell them, okay, I want you to shut down your Facebook. I want you to shut down whatever else you have at the time, MySpace, I don't remember. But in any case, that would be the advice that you'd want to give. I got tired of my clients lying to me and telling me that they were going to shut down their social media and, still keep them open. And I realized at a certain point in time that I was fighting a losing battle. People aren't going to just disappear from social media if it's become such a big part of their lives. And so it's better to manage what's happening as opposed to, hope that they're going to take the drastic step, but be disappointed down the road. So yeah, it is something where most lawyers have changed the advice they give over time. There's questions now whether, shutting down your account would even be permissible. A lot of times you're actually required to preserve what's there, which is fine. Right. And then you can get into an argument about whether it's something that you actually have to provide to the insurer.
Again, anytime you want to reach out to James and his team, 1-855-821-5900. There's also a website you can use, pocketemploymentlawyer.ca. Why? Because there's a section on that website all about disability law. We'll ask you a series of questions and help you out in that regard. And of course, there's contact information at the Pocket Employment Lawyer website as well. But I want to get a phone call, James. I did just mention disabilityrights.ca. That will jettison you to our firm website, and there's a media tab there. You can find a radio station across the country where you can catch the show, and people do by the thousands. We've been doing it for almost a decade, and people call in. They have great questions, and we'd like to bring them on this show and talk about them. We'll get to our first phone call for today's program, James, right now.
I work in the oil refineries. I went for my yearly hearing aid appointment. The doctor said that my hearing got substantially worse. Did all the paperwork for me, sent it in, said that I should qualify for something because I had permanent hearing loss, 45% on one side. And they basically refused it. They told me I had a date where I can appeal it. I still suffer from this hearing issues.
Appealing, your favorite part of the show. You love appeals.
Well, okay, let's talk about the appeal process. I think when people look at long-term disability and the whole process involved with LTD, one of the biggest complaints is that it feels unfair. It feels like it's an imbalance of power. So during the adjudication process, when you are applying for benefits and sometimes when you're approved for benefits, you have to act according to whatever's in the policy. If you don't do so as the insured person, then the insurance company is just going to cut off your benefits. That's what they will do if you don't follow the policy. But if the insurance company doesn't follow the policy, there's really nothing that you can do about it. There's no one that's overlooking the insurance company. You don't have any benefits to cut off for the insurance company. There isn't equal recourse that you have compared to what the insurance company is able to do if you don't follow the policy. And so that is an imbalance of power. You're playing on essentially a tilted battlefield. The insurer is starting from the high position and you're starting from the low position. And that is just the way that it plays out. Now, if the insurance company is playing fair, if they are paying your benefits as the case goes along, as your claim goes along, then that's fine. Even if the battlefield is tilted in their favor, as long as they're doing what they're supposed to do, okay, you'll continue to play by those rules. But as soon as they cut off your benefits, as soon as they stop playing by the rules and you no longer are getting your benefits, why would you continue to play on their battlefield? Why would you continue to give them the high ground? If you appeal, that's exactly what you're doing. you are giving the insurance company the high ground, because the appeal process is not something that is dictated by law. It's not something you find in the policy. It is something that the insurance company is making up. It is something that they do in order to prevent you from bringing a legal claim. And so all you're essentially doing is saying to the insurance company, I'm going to continue playing by your rules, even though it's unfair. What's the better option? Well, you bring a legal claim, and all of a sudden, you're no longer playing on a tilted battlefield. Now, a lot of people don't want to do that. A lot of people think about, oh, I'm bringing a lawsuit, which means I'm going to go to court and I'm going to have to go in front of a judge. Well, that's exceedingly rare. You're making sure that the insurance company knows that there is a consequence if they don't act reasonably. And you know, John, it's really interesting how reasonable insurers act as soon as you bring a legal claim. All of a sudden, they come to the table. All of a sudden, they understand that you're actually disabled and are entitled to benefits, and they're willing to pay several years into the future. I've seen it happen too many times for it to be a coincidence.
Let's take a short break, James. I want to come back with the 3 key facts to remember if you're denied LTD. That is on the way. As we go to break, here's the number to reach out, 1-855-821-5900. Email help@disabilityrights.ca. We'll continue. This is the Disability Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, we're back. Thank you for sticking around. John Scholes, James Fireman beside me, partner Samfiru, Tumarkin, LLP, the most positively reviewed and disability law firm in this country. Want to get into our topic for the day, James, and that is 3 key things to remember if denied your LTD claim. Number 1 kind of dovetails into what we were talking about just before the break, and appealing a denial may, I underscore the word may, be ineffective and a waste of time for that matter.
All right, so I just spent a lot of time in the last segment about the reasons why not to appeal. It's giving too much power to the insurance company, and there is a much better option to make sure that they're reasonable. So why don't I just spend a little bit of time going behind the curtain a little bit so you can see exactly what is happening and why it's so ineffective. So first of all, what actually happens when you bring in an appeal? Well, there isn't really a clear answer to that. And the reason for that is because it's not a formal process. Again, there is no law that says this is what happens when you appeal the denial or termination of your disability benefits. It's not defined in your policy. And each insurance company makes up their own rules for how their own appeal process is going to work. Sometimes when you appeal, it's going to be sent to an appeals specialist. Sometimes it's sent to an appeals panel. Sometimes it's sent right back to the same claims handler that adjudicated your case in the first place, the very same person that made the decision that you're appealing from. It's not sent to someone independent, though. It isn't sent to somebody who doesn't work for your insurance company to look at with fresh eyes. How many appeals are you allowed to do? Well, that also changes insurer to insurer. Some of them will tell you they'll do 2 or 3. Some of them won't put a limit on it. Some of them will tell you only 1 or 2. But I've seen every insurance company that I know of do multiple appeals, some as many as 6 or 7. And so when I say each insurer is making up their own rules, it's important to note that there's also nobody overseeing the process. And since they make up their own rules themselves, they can break the rules whenever they want to. The point is this: if you think about the appeals process as a competition where you're competing for those monthly benefits, there's several $1,000s a month at stake. But your insurance company gets to make up all the rules. And if they don't like how things are going, they can break the rules whenever they want to. How fair do you really think the insurance company is going to be when that's the setup for the competition? Not very.
It's interesting, too, because just that word appeal makes it sound like it goes to some federal or provincial board, you know, something that's all official that you're going to have a chance of winning, but it stays in-house, right?
Yeah, I mean, they use that terminology quite deliberately because it sounds very official, but really they could call it a pretty please will you change your mind, and that would be probably much more descriptive of what's actually happening.
We're talking about the 3 key facts to remember when denied LTD. Number 2 is this, James, you have 2 years to take action against the insurance company after the initial denial.
Yeah, that's really key, that last part, the initial denial. So from the date they deny your benefits or terminate the benefits that they've been paying you, the clock starts running and you only have 2 years to start a legal claim to challenge them. It doesn't matter how many times you appeal. I told you before, I've had clients that came to me after 6 or 7 appeals. Thankfully, that was still within the 2 years and I was able to bring a claim. But had those appeals stretched out for more than 2 years, and it easily could, all of a sudden, you no longer have the right to bring a legal claim. And as soon as you're out of time to bring a legal claim, your insurance company, they're not going to listen to your appeals anymore. That's going to be it. You're going to have absolutely no recourse.
Number 3, the third one of the key thing to remember, James, is rather than accept an LTD denial, you can talk to a disability lawyer to find out what your options are, and should talk to a disability lawyer for sure.
Yeah, absolutely. If you're wondering whether or not the insurance company was justified in terminating your claim, give us a call and we're happy to provide you with the free consultation and provide you with our assessment. And keep in mind, we work on a contingency, which means we only get paid if we're successful. What that means is we're not going to tell you that you have a valid case just to make you feel good or just to try and convince you to sign up. We do not want to be retained by clients who don't have a valid case. So we take our time and we make sure that the cases we're retained on are cases that are very likely to be successful down the road. And we'll tell you one way or the other. If we don't think that you have a valid claim, we'll not only tell you that, but we'll tell you exactly why we don't think so. And if there is a way to make your claim stronger, we'll tell you exactly what you need to do in order to set yourself up.
Look, if you have any other questions for James about the topic we just covered or anything else, here's how you reach out as we get into a break and come back for more. 1-855-821-5900, help@disabilityrights.ca. And after the break, we're going right to mydisabilityquestions.com as well. This is the Disability Law Show. It continues, so stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Disability Law Show. I want to direct your attention to a website called mydisabilityquestions.com. Why? Because it's exactly that. You can ask questions about your disability or anything you're wondering on your behalf, or a friend or a family member, colleague, no problem. It's free, it's anonymous, and the database within mydisabilityquestions.com is searchable. So your question may have been asked and answered previously, which will save you some time. If not, leave it there. James or a member of his team will get to it rather quickly. James, Layla is writing in again through mydisabilityquestions.com, says, my mother is on dialysis due to an extremely rare kidney disease, resulting in extreme fatigue, which makes it difficult for her to work. When she applied for long-term disability benefits, she was denied. Was the insurance company's decision fair, or should she have been approved?
Well, Layla, thank you so much for writing on behalf of your mother. If you are out there, if you have a family member or close friend that is involved in a disability insurance dispute and you'd like to get information for them, by all means, you can contact us on their behalf. You don't have to provide any personal information or identifying information. We're happy to give you our advice. And if they find it useful and want to talk to us directly, we're always happy to do free consultations as well. Now, to get to your question, Linda, about your mother. So first of all, you got to be really confident in the assessment. I would need a little bit more detail. I need to know what your mother's occupation was, the frequency and duration of her fatigue, and so forth. But even with the information that you provided, the details that you put in your email, it's hard to imagine a scenario where your mother isn't going to be entitled to those benefits, where a judge looking at this would say that the decision by the insurance company to deny the claim was proper. Now, insurers generally don't like to pay out benefits when the primary limitation is fatigue. And the reason is because fatigue is entirely a subjective feeling. It's something that everyone experiences differently. It doesn't mean it isn't real. It's very, very real and can absolutely be a limiting factor in something that can justify the payment of disability benefits, but it is a subjective disability. So in Layla's condition, or Layla's mother's condition, though, she's got a very rare form of kidney disease. And presumably that's not something that's in dispute. Presumably there is medical information that shows unequivocally that her mother has this kidney disease. Now, I'm not a doctor. I don't give out medical advice, but your kidneys are there to clean your blood, to take out toxins and impurities. And when your kidneys aren't working properly, and when those things are left in, the most common symptom is going to be fatigue. If you look it up online at any of the reputable medical sites, you'll look at symptoms of kidney dysfunction, and it's right there. Number one is fatigue. So this isn't something that is unexpected when you're dealing with someone who's got a rare kidney condition. Now, maybe there's some other explanation, or maybe this particular kidney condition wouldn't result in fatigue. Again, I'm not a doctor, I don't know, but connecting the dots, it looks like it's a pretty clear argument there that if you have kidney disease, there's going to be at least some fatigue. And if there is medical support that the fatigue is sufficiently limiting, that she's not able to do her work, then there is a valid claim there. That's the analysis right there. Again, I don't know what the job is, and I'm not really sure the extent of the fatigue. Some people might describe extreme fatigue as fatigue that limits them to being able to only function 6 or 8 hours a day, which might be enough to do work. Other people would say it's extreme fatigue when you can really only function for an hour a day. So I don't know what it means in terms of Layla's mother, what extreme fatigue actually equates to. I would need to figure that out. But it certainly sounds like there's a valid basis for a claim there, and it's something that we would absolutely be willing to assist with, as long as the medical records support everything that's said there.
I want to get to an email from Rakesh, writes in, says, James, can I quit my job while I'm using long-term disability benefits?
Sure. I mean, you can. I don't really know why you would want to. I don't know what the advantage to quitting your job would be. For most people, or at least for a lot of people who are on disability benefits, especially in a group disability plan, they are also getting extended health insurance through their group plan as well. And if you quit your job, you're going to lose access, in most cases, to that group health plan. And you're going to lose any opportunity to get severance or termination pay down the road. And you're not going to be able, as far as I understand it, to be able to apply for employment insurance. So you could, and you would still, that wouldn't change your entitlement to disability benefits. You don't need to maintain your employment with your employer in order to continue getting disability benefits. But I don't know why you would go through the process of formally resigning from your job. I don't know what that gets you. So without any further information, without understanding exactly what it is Rakesh is getting at here, the answer is yes, but why?
I think when I read Rakesh's email, I think the more common question we've had over the years is, if I'm let go from my job, am I going to lose my disability benefits?
Sure, and that's something that comes up quite frequently. And the answer to that is absolutely not. If you are terminated from your position while you are getting disability benefits, you are still going to continue getting those disability benefits right through to age 65, as long as you continue to be disabled from the occupation that you had at the time. Doesn't matter if you no longer have your job, you continue to be entitled to keep those benefits as long as you are disabled. So if that's really what Rakesh was getting at, then sure, it's not an issue for you at all. But would you actually go to the formal process of quitting your job? I just don't understand why.
I want to get to Hannah quickly here. It says, I've been experiencing chronic pain and difficulty moving my left foot ever since I had knee replacement surgery almost a year ago. The surgeon said it may take some time before I regain full use of the limb. Out of the blue, my insurance adjuster has started asking me a growing list of questions. I feel like he may be trying to cut off my payments soon. What should I do?
Well, when your insurance adjuster starts coming out and asking you a lot of questions out of the blue, it is a reasonable conclusion to draw that they are looking at your case more carefully. So it's certainly fair to be concerned about it. What do you do in this particular case? Well, go back to first principles, what I say all the time. Whenever you're communicating with your claims handler, it's really critical that everything you do is reduced to writing. So anytime they are calling you, you stop and you say, okay, I need to get a pad of paper and a pen. I just need to take some notes. And just don't say anything until you have it. Have the conversation, take the notes, and as soon as you're done, send an email summarizing everything that's been said during that conversation. This is going to make sure that if the insurance adjuster is trying to suggest something to you that isn't actually so, that there's going to be a record of that, and more likely than not, if they do that, they're going to back off from that position. The other really important thing is to make sure that the insurance company has all of the updated records from your treatment providers, and in particular, the opinions from your surgeon. You want to make sure that your treating doctors and particularly specialists are going to provide information on your prognosis and the likely duration for recovery, so that there's no basis for the insurance company to say, okay, well, we didn't have any information about how long you were going to be disabled from work for, and on that basis, we're denying your claim. You want to make sure there's a record of that. Now, I'm not going to tell you, Hannah, that if you do all of this, your insurance company isn't going to cut you off. Very often, your insurance company is going to deliberately set down a path to terminate your benefits and look for any justification to do so. But what's critical is that you put yourself in the best position possible, so that if and when they decide to cut off your benefits and you have to bring a legal claim in order to recover those benefits down the road, the file is going to be in good condition. It's going to be set up so that we can successfully challenge the claim by bringing a legal claim to challenge that decision.
These notes that you send off, these contemporaneous notes, does it matter if they reply to them, or is it a matter of, silence is acceptance if they don't respond to you?
Yeah, I think that's pretty much it there, John. So if you send an email summarizing a conversation and the claims handler doesn't respond to it at all, they're basically accepting that your version of events is true. And that's fine. If they want to correct something, in other words, if you've said that the insurance adjuster has suggested something and they say, oh, no, that's incorrect, well, that's fine too, because now there's a written record of that correction and you don't have to argue about it down the road.
Covered a lot of ground on the show today. Appreciate all your input through the phone calls, the emails, and mydisabilityquestions.com as well. You can always use that. It's free and anonymous. The email address, help@disabilityrights.ca. And finally, that phone number, use it. Call James and his team, 1-855-821-5900. We'll catch you next time on the Disability Law Show.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.